So let's do a quick rundown of the session today. So we're going to start with some teaching. This is going to be the boring part of it, but I've chosen the subject of criminal law, which has got lots of very interesting cases. So hopefully the teaching will not be as boring. Then we're going to go through the preparation questions that I sent out before the session. I hope that you've been able to have a look at the questions and have a think about, what you think about them. And after the teaching, hopefully you will all be able to answer the questions perfectly. So we'll go through those questions, and then we'll have a conclusion. And at the end, we'll have 15 minutes of question Q&A, because I'm sure there's a lot of people who are interested in law. So that's going to be the rundown. And before we begin, I just want to give a quick warning that, yes, I'm going to be going through criminal law. Crime is obviously quite a sensitive topic. There's all sorts of, murders and all that. So if you don't feel comfortable listening to something, listening to descriptions of violence or crime, feel free to leave the meeting. It's obviously not a thing that is for everyone. So that's just to give a quick warning for anyone who might not want to hear that sort of stuff. Right, okay. So today we're going to be going through the topic of causation in criminal law. So what causation means is basically that when you're trying to prove a crime has been committed, you have to prove that the action of the criminal correlates to the harm, the results that is suffered by the victim. So it might seem really obvious, if someone shoots another person, that person has caused the death of the victim. But in a lot of cases, it's not as straightforward as that. And that's why we need all these rules to kind of regulate the area. So, so there's 4 principles when it comes to causation that we need to think about. So there's factual causation, which we will go through all of these one by one, so don't worry if you don't know what it means. Factual causation, which means that factually it was caused by the harm was caused by the act. There's legal causation, and then there's the chain of causation, and finally there's a special rule called the thin skull rule, which we'll go through all of these in turn. So firstly, the factual causation. So again, this just means that factually the act of the person, like shooting the victim, has caused the death. Oh, so sorry, I will remove the poll. Sorry, I'm not quite sure how I can remove the poll, but I think you can just click a little cross on it.
It's fine, Aurora, now. Yep, thank you.
Okay, perfect. Right, so factual causation. How the law tests factual causation is through the but-for test. The but-for test means that but for the act of the defendant, the criminal, the harm would not have happened. So in the case of the shooting, but for the fact that the defendant shot the gun, the victim would not have suffered a gun wound and therefore would not have died. So that's the legal test that is necessary. And just to give you an idea of how that works, I'll tell you about the case where it was established. So that's R.V. White. And just an introduction to how to interpret the names of cases. So the R means Regina or Rex, which means the king or the queen, because all criminal cases are prosecuted on behalf of the crown. So it's the state against the person. In America, it would be the state v whoever it is. But in the UK, because we're a monarchy system, it's R v whoever it is. The year of the case is in the brackets, and all those random numbers after that is just the citation for the case. So in which book it is found, in which volume of the book, in which chapter or whatever of the book. So in the case of R.V. White, the defendant had put poison in his mother's drink, and he was planning to kill her over multiple doses of poison. The victim drank this drink. She then fell asleep and she died of a heart attack in her sleep. So medical evidence showed that the death was only caused by the heart attack and was completely unrelated to the poison. So the court decided that, but for the actions of the defendant, even if he had not poisoned the mother's drink, the victim would still have died, and therefore he was not guilty of murder, because but for his actions, the harm would still have been committed. So that's the factual causation. Just to give you another case, it's the same principle, R.V. Dalloway. The defendant in this case was a horse and cart driver. He was on a journey, he was taking his cart out, and he was not holding on to the reins of the horse while he was driving. So that's kind of like driving without your hands on the steering wheel. So a child ran in front of the cart while he was driving, and the child was run over. However, the court found that even if he had been holding on to the reins, the child would still have been run over because the collision was unavoidable. So in a modern day setting, if a kid ran in front of a car, and it was held that the driver couldn't have seen the kid or have stopped in time, there was nothing that the driver could have done. So in this case, the driver was not responsible, was not held liable, because but for the fact that he had not been holding on to his reins, the harm would still have happened. So those are some cases to illustrate how the but-for test works. Moving on to the next principle is legal causation. So it's not enough that it happened factually; it also has to happen. That it also has to be liable in a legal sense. So legal causation is usually only relevant where there are multiple causes of death of the harm, not necessarily death. And legal causation means that the defendant must have been substantial, the defendant's act must have been substantial, culpable, and also that the harm was foreseeable. So what do all these words mean? If you do study law, you'll come to be very familiar with these words, but they're not very common words in everyday life. So I'll go through what each of them means. So substantial means just that it was more than trivial. So basically that even if there were multiple causes of why the victim was harmed, the defendant's action was more than minimal, that it was still that it was still something, it was still significant. Again, I'll use a case to illustrate what it means, because it's kind of hard to understand these principles just in abstract. So the case R.V. Dench, the defendant was a railway foreman. So he was in charge of ordering the track repairs, of doing the scheduling of when everything would happen. So he misread the train timetable. So he thought that the train had already gone, but in fact, the train was still on the way to the station. So he ordered the track repairs because he thought the train had already gone, and the tracks were removed from the ground. And then the train came into the station, and because the tracks were gone, the train collided. It crashed and several people got injured. So the defendant is obviously at fault, but there were also other people at fault. So for example, the signal man, he was in charge of giving signals to the train. He didn't signal the train to go another way, to stop. And the driver himself was also not paying attention to what was going on in front of him. So he didn't see that the tracks were gone. So he didn't brake in time. So these other people were also to blame. However, regardless of the fact that there were multiple causes, that multiple people were at fault, the court still held that the foreman, the railway foreman, he was still a substantial cause, that he had more than minimal effect on the result, which was the train crashing, and therefore he was still liable for it. So that's substantial, more than trivial. And the next principle is culpability. Culpability means that something is legally or morally wrong, that it's blameworthy. So, for example, in the case of the horse and cart driver, so we remember the fact that he wasn't holding the reins. Not holding the reins is against the law. That's like not holding the steering wheel of a car. That's also breaking the law. So that's something that's culpable. If he had been holding on to the reins, if he had done everything right, like followed the rules, had the equivalent of a seatbelt on, then he would not be culpable. He couldn't be blamed for whatever happened, even if he got into a car crash. If he had done everything right according to the law, then he wouldn't be liable. And finally, foreseeable. So the results must have been foreseeable from the action of the defendant. For example, going back to the case of the shooting a gun, it's foreseeable that if you shoot someone, they would die. That's a foreseeable result. Another example, if you throw a rock at a window, it's a foreseeable result that the window would break. What would not be foreseeable is that if you threw a rock at a window, that someone would have a heart attack as a result. So it's something completely unexpected. You wouldn't be liable for that. So that's legal causation. So we have to have factual causation, we have to have legal causation, and finally, we have to also think about the chain of causation. So the chain of causation means that when there are multiple causes that lead to the result, the chain can be broken by an intervening act. This act can be committed by a third party, by the victim, or by natural events. So for example, if you were planning if you're planning to damage a building, but then the building was blown over in a hurricane or whatever, then that hurricane has broken the chain, and you will no longer be liable because the hurricane is now the cause of the result. So these intervening acts have to be independent, unforeseeable, and overwhelm the defendant's contributions. So again, what do these words mean? If you study law, you'll be very familiar with them, but I'll introduce them to you now. So firstly, it has to be independent, which means that it has to be a voluntary and free act of the third party or victim. So it can't be that the defendant forced the victim to do something, and that doesn't break the chain of causation. Again, I'll illustrate this with a case. That's the easiest way to understand. So in the case of R.V. Kennedy, this was a case of a where the defendant was a drug dealer, and he had sold some drugs to the victim. The defendant handed the syringe to the victim and helped him to find a place to inject, and I think helped to tourniquet his arm and all prepare to inject the drug. However, the victim was the one who voluntarily and independently, okay, hang on. Is the slideshow back? Okay, perfect. So the victim ended up being the one to actually do the injection into his own arm. And that was held to be an independent and voluntary act. So even though the drug dealer had helped him to set up all the equipment and stuff like that, it was in the end still the victim's own decision to do the injection. So that was held to be an independent intervening act. So the drug dealer wasn't, the victim had then died from an overdose. So it was held that the victim was liable for his own death because he had chosen to inject himself rather than the drug dealer being held responsible. So the victim's act had broken the chain and the drug dealer was no longer liable. Next principle is that the intervening act has to be unforeseeable, meaning that it was not a natural consequence or a natural response to the defendant's act. So again, case law to illustrate. We will compare two cases which had similar circumstances but led to different results. So the first case is R.V. Roberts. The defendant was a man. He was driving a car. He gave a lift to a woman, to the victim. The victim was in the defendant's car. The defendant then made unwanted advances towards the victim, and the victim, in order to escape him, jumped out of the moving car, and she suffered injuries from that. So in this case, the court held that the defendant was liable for the victim's injuries because the victim jumping out of the car to avoid his unwanted advances was a natural and foreseeable consequence. So it is that meaning that, you know, anyone could predict that if you made these sexual advances as a single vulnerable woman, the victim would have a possibility of jumping out of the car to escape him. So to compare that with another case, also very similar, that the victim was a hitchhiker that the defendants had picked up in their car. So this is R.V. Williamson Davis. Similar circumstances. The defendant tried to rob the victim, and the victim jumped out of the car to escape and sustained a head injury. However, in this case, it was held that the victim's action of jumping out of the car was not foreseeable, because there was no evidence of any threats or any fear of violence. So the defendants hadn't threatened him in any way. They hadn't tried to use violence. That they had just basically, you know, asked for money. And in that case, it was not within the range of reasonable responses to jump out of the car. So that was seen to be out of proportion, something that's completely unexpected for a normal person. So that's basically what foreseeability means. Finally, in the case of medical negligence, there's a very special rule that protects doctors because obviously medical mistakes happen all the time. And if doctors were held to be criminally liable for a patient's death every single time, it would make a doctor's job really, really hard. So there's a special rule to protect them from medical negligence, which means that the medical negligence cannot overwhelm the defendant's contributions unless it was a really, really, really bad negligence. So the doctor must do something really, really incompetent, just make a really huge mistake for that to count, basically. So again, let's look at two cases that are similar circumstances, but different results to illustrate, when it's too bad and when it's not. So in the case of R.V. Jordan, the victim was stabbed. The victim was stabbed and he later died in the hospital because the hospital had prescribed him a drug that he was allergic to, and had prescribed way too much, so an excessive dosage. So this was held to be grossly negligent because I'm not sure why the language keeps changing. Maybe Pravahi, could you have a look at that? Sorry. So the doctors in this case was held to be liable because they had made such a huge mistake in giving the victim something that he was allergic to, firstly, and giving him excessive doses. So this is beyond a simple mistake. It was judged to be such a serious mistake that the doctor's responsibility overwhelmed the defendant's responsibility. So the guy who had originally stabbed the victim, and the doctors were held to be liable instead of the defendant. So let's compare that with another similar case, R.V. Cheshire. In this case, the victim was shot, and he later died because of medical complications, because of the tracheometry pipe that they had inserted to help him breathe. There was certain complications that arose, which blocked his airway, and he eventually passed away due to that. So in this case, it was held that the original defendant, the guy who had shot the victim, was still responsible for the victim's death because the medical negligence wasn't serious enough. The mistake the doctors had made wasn't serious enough. It was a really minor mistake, and it was mostly just due to medical complications after the surgery. So it wasn't really the doctor's fault. So in that case, it wasn't serious enough to overwhelm the defendant's responsibility. So that didn't break the chain of causation. So just to summarize, we need intervening acts to be independent, unforeseeable, and to be overwhelming the defendant's contributions in order to break the chain of causation so that the original defendant is no longer liable. And then finally, we have this special rule, which is called the thin skull or the eggshell skull rule. Basically, it means that if the victim has a special mental or physical characteristic that makes them like especially vulnerable, then the defendant is still liable for the harm that is caused to them. That the quote that is used all the time is that you must take the victim as you find them. So it's called the eggshell skull rule because the example that is used all the time is if the defendant has a special condition that makes his skull as thin as an eggshell, that it's really thin, and you had pushed the victim over, and the victim, I'm really not sure why the language is changing. I hope maybe we can fix that soon. But I mean, you can still hear me all right, so just ignore the language. Back to the eggshell skull rule, the idea is that if someone had a thin eggshell skull and you pushed them over and they died because of that, because their skull is so thin, you'd still be responsible for their murder because it's their special condition does not break the chain of causation, basically. Again, let's look at a specific eggshell skull rule, it's called. So the example is that if the victim has a eggshell thin, like a really thin skull, that's like an eggshell that if you pushed him over, his skull cracked, which is obviously not a normal condition. That it's like it must be a special medical condition. You'd still be liable for their murder, even though a normal person wouldn't die if you pushed them over, because you must take the victim as you find them. So A case that is used to illustrate this is the case of RV Blue, RV Blau, something like that. So the defendant had stabbed the victim 4 times. The victim was then brought to hospital and she needed a blood transfusion, but she denied this procedure because of her beliefs as a Jehovah's Witness, which doesn't allow her to get transfusions, blood transfusions. So she died as a result because she didn't have the treatment. So the court held that her special condition of being a Jehovah's Witness and not being able to receive blood transfusions, that's not that cannot be used to take the blame away from the defendant. The defendant is still responsible for her death. So the eggshell skull rule applies not just to physical conditions, but also to beliefs. So this case is not it's a bit questioned now. It's kind of strange to think about it, to what extent we can extend this to, what kind of beliefs you can use as excuses. So, but a lot of laws like this, that cases are debated upon, whether the right judgment was made, but that's still the law right now. So that's the rule right now. So yeah, that's the eggshell skull rule. And that finishes up our teaching section, which I hope you found interesting. So we're now going to move on to the preparation questions that I had set to you guys. And now that you've learned all the principles, now that you know everything, hopefully you can now solve those questions. So how we're going to do this is I will demonstrate how to answer the questions with the first example, and then I'll ask you guys what you think about the other 2 questions. So the first questions, I'm not sure if you guys still remember this, but this is the one with the water balloon fight. So Sam and Peter are having a water balloon fight. Sam throws a water balloon at Peter, and the balloon hits Peter's eyes, so he becomes blinded. He falls backwards and he bumps his head. He also falls on Jason's toy car, which is crushed and broken. So in this case, let's look at so I'll go through the questions first, and then you can give a shot at answering the other questions. So in this case, for question A, who should be responsible for Peter's head injury? Let's first think about the factual causation. So, but for the fact that Sam threw the water balloon at Peter wouldn't have fallen down randomly. So clearly, Sam caused the Peter to fall down. So factual causation has been established. Next, we need to think about legal causation. So when we think about legal causation, remember it needs to be substantial and blameworthy. So throwing that water balloon wasn't a good thing to do. It would be considered blameworthy, and substantial because there was no other causes, so automatically it does satisfy the legal causation. So there's no chain of causation. So the answer to A would be that yes, Sam is the one who is responsible because he has legal and factual causation, and there was no chain of there were no intervening acts. So when we go through the question, we have to go through it systematically. You have to address factual causation, legal causation, and intervening acts. You have to talk about each of these in turn in order to get full marks on an exam. So I see a lot of you are just responding Sam as the answer, which is the right answer, but it's like doing a math question if you just wrote down the answer, you wouldn't get full marks. You have to write down all of the steps that lead you to get the answer, because the examiner has to understand that you didn't just like guess the right answer. They have to understand that you got to the answer through the right reasoning. So it's really important to go through all of the steps of the reasoning process. So let's do another example. So the question B, who is responsible for Jason's toy car breaking? Once again, we want to look at the factual causation first. So, but for the fact that Sam threw the water at Peter, Peter would not have fallen down, and if Peter hadn't fallen down, the car wouldn't have been crushed. So we have to establish the link there very clearly, like because of this happened, because of this happened. Legal causation, again, we've established that Sam throwing the water balloon was blameworthy and substantial. And it is foreseeable that if you throw a water balloon at someone, they might fall down. So the chain of causation, Peter's action of falling down is a natural reaction, because basically it's a foreseeable and natural reaction to being hit with a water balloon. So that does not break the chain of causation. So Sam remains the one who is liable. And then part C, I've seen quite a few good answers. If anyone else has some more answers, you can pop that in the chat. So it is, you're right. For example, if they agree to a water balloon fight, that does change the circumstances, because maybe you can say that that Sam's action of throwing the water balloon was not blameworthy, that he was not culpable, because they had agreed to it. So that's a really good one. Let's see. Yes, another really good point I see is to ask, why was the car there? So if, I don't know, why was the car on the floor where it could be crushed and not put away? Maybe Jason had forgotten to put his toy car away after playing with it. And in that case, Jason would be maybe held responsible as well for his own toy car breaking, and that might maybe alleviate Sam's responsibility for the car being broken. So these are really good questions. When you're answering legal questions like this, you can't just rely on the facts. Often you have to think beyond the facts to think what's missing. And I see a lot of really good answers here. So let's move on to the second question. So that's the chemistry class. So John decides to pull a prank on Max, and he scares Max, and Max is holding a match, which she drops onto a pile of paper. The paper lights on fire. The fire damages the equipment and the tables. And also, they have a classmate, Leo, who has asthma. The smoke triggers a serious asthma attack. So firstly, let's talk about the property damage, right? So let's try to answer in terms of factual, legal, and chain of causation. So who would be responsible for the property damage? And make sure to answer why. So why would he be factually responsible, legally responsible, and whether there are any intervening acts. Yes, so the answer, you're right, is John, but once again, we need to give reasoning for that. Okay, so those are some good questions that we want to be asking. Why was Max holding a match? Well, it was chemistry class, so probably he was doing some, I don't know if you guys have used a Bunsen burner. Maybe he was lighting the Bunsen burner to do an experiment for chemistry class. Yes, so that's a really good answer that I've seen. That gives an answer about Max dropping the match after being startled is a foreseeable event. That's a natural reaction to being scared. So Max doesn't have responsibility for the fact that he dropped the match. So John is the one who was irresponsible. So that's a great answer. That answers, why he was factually responsible and also why he was legally responsible. Yes, and I see another great point being made. John shouldn't have tried to scare him because he is in the lab, which means he knows it is dangerous. That's a very good point because John should know that, it's dangerous, that you're working around dangerous chemicals with dangerous materials. He should have probably seen the fact that Max was holding a match and known that if he scared him, he would drop it. So that's a really good point. The fact that they're in chemistry class makes John more responsible. So he's more blameworthy because his action was more wrong. Yeah, those are really good points. I also see a lot of people talking about the teacher maybe being responsible because he should have been in more control of the classroom. That's also a great point to make. Maybe, the teacher has a duty of care over all the children that he is teaching, so he should have been maybe paying more attention. And that's a really good point because the question didn't even mention a teacher, so the fact that you thought about that, that's really good. Why was there a pile of paper? I mean, it could have been like the worksheets that they were using to fill in, but good questions to ask. Right. Okay. Yeah. So I see a good question, a good answer talking about the thin skull rule. So Leo's asthma would be a special physical condition, just like having a thin skull or being a Jehovah's Witness. So actually, the thin skull rule means that the defendant still remains liable for the victim's injuries, even if the victim had some special characteristics. So in this case, John would be to blame for Leo's asthma attack because you have to take your victim as you find them. So he cannot be like, oh, it's not my fault that he had asthma. Um, in fact, the court would say that you have to you have to be responsible for Leo's asthma attack. Leo's asthma, it's not Leo's fault either. In that case, it would be no one's fault. And criminal law does not like there being no one at fault. So in this case, John would still be liable. Right. So I've seen quite a few good responses to this question. So maybe let's try moving on to the next question because I'm aware of the time. I want to leave lots of time for you guys to ask questions. So let's go on to the third one. So that would be the football question. So Mandy and Jill are playing football. Mandy commits a foul by tripping Jill, and she falls and scrapes her knees, and her knees begin to bleed. Later that day, she decides to go swimming in a dirty lake, disregarding that she has an open wound and she gets an infection. So who's responsible for the fact that Jill got an infection? So once again, we want to be thinking about factual causation, legal causation, chain of causation. So let's talk about factual causation first. So that means that the but-for test. So let's think about, but for the fact that Mandy had tripped Jill, would Jill still suffer the injury? Right, okay, yeah. I'm seeing a lot of answers that Jill should be responsible because she shouldn't have gone swimming in the lake. So if we think about the RV Kennedy case, that's the one with the drug injection. The victim chose to inject the drug in the end, and therefore the victim was held responsible for his own actions. So applying it to this case, it's similar that Jill also chose to go into the lake because like of her own voluntary will. And if she hadn't done that, then she wouldn't have gotten the infection. I do see a good response that talks about factual causation. So Mandy is to blame. If she had not done the foul, then Jill wouldn't have an open wound in the first place. So that's a really good point because if Jill had gone swimming with no wounds, she would be fine. So we can see that, it's not that Jill is at fault, surely, but Mandy is at fault as well because she was the one who caused there to be a wound in the first place. So if we're thinking about the but for test, but for the fact that Mandy had injured Jill, Jill wouldn't have an infection. So in this case, it would be very likely that they would both be to different degrees responsible for the fact that Jill has an infection. And then I see some really good questions that we want to be asking beyond the information that is provided. Did Jill know the lake was dirty? That's a really good point. What if there was a situation where there was a sign next to the lake saying that the water is clean and that there's no problems with the lake? What if someone had put a sign there that the city council had put a sign that the lake was safe to swim in? In that case, it wouldn't be Jill's fault for swimming in that dirty lake because she thought it was clean and safe. And in that case, it would probably be the fault of the person who put the sign there because they had basically lied on the sign to say the water was clean. Um, Also another really good point, how old is Jill? If she was young, then her parents are at fault. That could definitely be true. Maybe if her parents were supposed to be watching her, if she's like really young, if she's like 4 or 5, her parents would be responsible because obviously if she's like 4 or 5, she's not going to know that she's going to get an infection from swimming in dirty water. Um, that's another really good point. Yep, that's also another good point I see. Maybe Jill already planned to go to the lake. Maybe Jill even told Mandy that she was planning to go to the lake that day. So so Mandy already knew that she was going to the lake later today. Um, I mean, in that case, probably Jill would still be a bit liable knowing that, that even if she had made plans, she should have canceled the plans because she had an injury. But still, that's something really good to be thinking about. I see a really good answer saying that it says she disregarded it, which means she realized it would infect her and chose to ignore it. So that's something that's a really good skill as well to pick up on the wording of the question, to look at the words, what the words mean, and and make conclusions about that. That's also really good. So I see a lot of different answers. I think some of you think Jill, some of you think Mandy. Actually, let's do a poll and see who thinks Mandy's at fault, who thinks Jill is at fault. Okay, the poll should be out. Okay, so everyone is saying Jill. Right, okay, so basically, okay, three responses for Mandy. 4, okay, so in this case, I think it's a pretty big split on who you think is responsible. But in reality, if you're answering an exam, there won't be a correct answer. So whether you answer Mandy or whether you answer Jill, as long as you give a really good reason for it, as I've seen some of you give really good reasons, you can still get a really high score. So in most law exams, there is no right answer. You can make any arguments that you want, and as long as your argument makes sense, your answer will be accepted, basically. In fact, the examiners really like seeing very like innovative, very like exciting answers that go against what other people say, because that shows original thinking. So if you are able to justify that Mandy should be the one who is responsible, you might get an even higher score in an exam, because no other student is saying that. So the examiner will be really interested in that. So yeah, no matter which one you think it is, as long as you can give a good reason, you will do great on your exam. So that's what law is all about. It's all about the debating, about like different arguments about all these things you're bringing in. Like maybe you could say that the parents are responsible. That's also a great answer to give, because no one else will be saying that. Um, so all of you seem to have the skills necessary to do well in law. And okay, so